Okay, so good afternoon everyone. Thank you for joining our webinar today. I'm Emma Waldron, WCVA's Risk, Procurement and Governance Manager, and I'm also WCVA's Data Protection Officer. This is our 9th webinar of the Desktop Data series, and with GDPR fast approaching, we need to be confident that we are well prepared ahead of the new regulations being implemented in May this year. Our speaker is Bethan Bonsall from the ICO. Welcome, Bethan.
Hello.
Bethan is the ICO's lead policy officer, and she's here today to discuss data sharing. So we anticipate today's session will take about half an hour, and there'll be an opportunity to ask questions. So if you do have questions, feel free to add them to the chat pane during the session, and we'll aim to answer them at the end of the presentation. And there will also be an opportunity to share your comments by completing a short survey, and we'll share details of that on the final slide. Okay, so over to Bethan.
Thank you, Emma, and good afternoon to all of you dialing in today and to those that are going to be listening at a later date. As Emma said, I'm Bethan and I'm the lead policy officer for the ICO's office in Wales. As many of you may know, the ICO is the UK regulator for the Data Protection Act, the Privacy and Electronic Communication Regulations, and other associated information rights legislation. During this webinar under the Desktop Data series, we'll be looking at the topic of data sharing. These webinars have all been designed to prepare charities in Wales for the upcoming General Data Protection Regulation, or GDPR for short, in May 25th of this year. So data sharing is an important issue and an area which many may feel daunted by or have some misconceptions about possibly. So before we make a start, just wanted to do something interactive and get a feel for how many of you here listening today have ever requested information from another organisation, whether it's your own kind of in your personal capacity or as part of your current role or a previous role. So you've requested information and been refused on the grounds of data protection law. So rather than asking people to vote by way of the webinar, if you could just type in the comments pane, the chat pane, and just say yes, I have, or agree, just so we can get a feel for how many misconceptions there are, not in your charities, but in other organisations, in terms of being refused information.
Okay, so there's quite a few comments coming through. Bit of a mixture, so yes, no, agree, yeah, many yeses, no, and someone has never been refused, no.
Okay.
That's
really interesting. So thank you everyone for contributing. Now, the reason I asked that is just, it's not uncommon for me to hear people saying, I can't possibly share that information, the Data Protection Act won't let me. So during this webinar, we'll hopefully be dispelling those myths and looking at the things that you need to consider as a charity in order to share information lawfully, not just under the current Data Protection Act. We'll then look at data sharing and your requirements under the law, so under the current DPA and as of May under the GDPR. We'll discuss how to share data in a fair and transparent manner, what you'll need to do in terms of security when you're engaging in any data sharing, how to ensure you've got the right governance mechanisms in place to support the data sharing, the importance of the rights that individuals have in relation to that sharing, and as many of you may know, under GDPR, individual rights are strengthened. And finally, we'll look briefly at data sharing agreements and the information that should be addressed by them. So we'll look at that throughout today's session. But let's go on to look at what we actually mean by data sharing. The ICO's Data Sharing Code of Practice defines data sharing as the disclosure of data from one or more organisations to a third party, or the sharing of data between different parts of an organisation, so different departments. Data sharing can take the form of a few things, but as an example, it could be a reciprocal exchange of data, one or more organisations providing data to a third party, or it could be something such as several organisations pooling information together and making it available to either each other or third parties again. And it could even be different parts of the same organisation making data available to each other. Now, there's two types of data sharing that the ICO's Data Sharing Code of Practice looks at specifically. So firstly, you've got systematic and routine data sharing, which occurs when the same group of organisations share the same data for clearly established purposes. The second type of data sharing relates to exceptional one-off decisions to share data for any of a range of purposes. For example, you might receive a request for information from the police about an individual that your charity holds information about. Different approaches apply to these two types of data sharing. Because the focus of today's webinar will primarily be on systematic routine data sharing, some of the good practice recommendations that we'll cover now won't apply to those one-off exceptional decisions to share information. We also won't focus largely on the sharing of data between different parts of an organisation, but it's important to remember that the data protection principles still apply to the sharing of data, even if it's just between different departments within your own charity. Although the main focus today will be on data sharing between different organisations, the advice I will be giving will still to some extent apply to internal data sharing. So before your charity decides to embark on any data sharing exercises, you'll need to consider the legal obligations or implications of sharing that information. Your ability to share information is subject to a number of legal constraints which go beyond the requirements of the Data Protection Act. There may well be other considerations, such as specific statutory prohibitions on sharing, copyright restrictions, or perhaps a duty of confidence that may affect your ability to share personal data. You may need to seek your own legal advice on these issues that we discussed now. So, if you want to share information with another person, whether by way of a one-off disclosure or as part of a large-scale data sharing arrangement, you need to consider whether you've got the legal power or ability to do so. This is likely to depend in part on the nature of the information in question, for example, whether it's sensitive personal data, such as health information or religious beliefs or sexual orientation. However, it also depends on who you are, because your legal status also affects your ability to share information. So just to summarise, the legal status of an organisation leads to different legal implications when sharing personal data. So for that reason, it means that public, private and third sector organisations have different considerations when deciding whether or not to share data. Now, because you're all listening in your capacity as a charity today, we won't focus on the legal implications of sharing data in the public or private sector, so let's look at what it means for you as a charity. Whilst public sector organisations may only act within their statutory powers, most third sector bodies have a general ability to share personal information, provided that sharing doesn't breach the Data Protection Act or any other law. However, it's advisable for you as a charity to check constitutional documents, such as your memorandum, to make sure that there are no restrictions that would prevent you from sharing personal data in a particular context. And also, as a charity, you should have regard to any industry-specific regulation or guidance about handling individuals' information, as this may affect your ability to share that information. Once you've determined whether or not you've got the legal power to share data, there's a number of other factors you'll need to consider before deciding whether to enter into an arrangement to share personal data. The ICO's Data Sharing Code of Practice gives examples of key questions to ask within your charity. So first of all, an example would be, what is the sharing meant to achieve? You should have a clear objective or a set of objectives. Being clear about these objectives will allow you to work out what data you need to share and who with. What information needs to be shared? You wouldn't share all the personal data you hold about someone if only certain items are needed to achieve your objectives. For example, you might need to share someone's current name and their address, but not any other information that you hold about them. Who requires access to the personal data? You should employ the need-to-know principles, meaning that other organisations should only have access to your data if they need it, and that only relevant staff within those organisations also have access to that data. When should it be shared? It's good practice to document this, for example, setting out whether the sharing should be an ongoing routine process or whether it should only take place in response to particular events. How should it be shared? This question involves addressing the security of the data and establishing common rules for its security. What risk does the data sharing pose? For example, is the individual likely to be damaged by that sharing? Is any individual likely to object, or would it undermine individuals' trust in your charity for sharing that information? Think about whether the objective that you're hoping to achieve could be achieved without sharing the data, or perhaps by anonymising it. If you can truly anonymise data, you won't have to worry about data protection laws, as the data won't be personal data. However, it is important, and it's worth looking at the ICO's Anonymisation Code of Practice to ensure that you are actually properly anonymising the data, because sometimes with small data sets, you might think you're anonymising information, but because that data set is so small, there's sometimes a likelihood of being able to relate that information back to identifiable individuals. Think about whether you need to update your charity's registration entry with the ICO to reflect the new purpose that you're using that data for. Ask yourself whether any of the data will be transferred outside of the European Economic Area, or EEA for short. If so, you need to consider the requirements of the 8th principle of the current Data Protection Act and the equivalent provisions under the GDPR. We're not covering the sharing of data between a controller and a processor during this webinar, but whilst we're talking about data being sent overseas, it's important to remember that with things like cloud computing, so using a processor to act as a cloud computing provider, you do risk sending data overseas without necessarily realising that you're doing so. So for those of you that want to find out a bit more information, our cloud computing guidance gives more information about what you need to do to ensure that if you are sending information outside of the European Economic Area, you're doing so in a way that's compliant with data protection laws. And in order to ensure that the sharing will be lawful under the current DPA and the forthcoming GDPR, you'll need to identify an appropriate legal basis under which to share the data. Remember also that for sensitive data, such as health information, you'll need to meet a further legal basis in order to justify processing information of a more sensitive nature. Let's have a little look at fairness and transparency now. So both the current Data Protection Act and the GDPR requires that personal data be processed fairly. This means that people should generally be aware of which organisations are sharing their personal data and what that sharing is being used for. In a broader sense, fairness also requires that where personal data is shared, this happens in a way that's a reasonable kind of manner and a way that people would be likely to expect and would not reasonably object to if given the chance. You need to think about this before you first share any personal data, and this not only applies to routine data sharing but also to single one-off disclosures. The ICO has already produced comprehensive guidance on drafting and distributing of fair processing notices, or privacy notices as they're sometimes called, in our Privacy Notices Code of Practice, which is the document you can see on the left-hand slide. You can also listen to a previous webinar we ran in August of last year under the Desktop Data series, which looked at your obligations about communicating privacy information to individuals. So I'd recommend watching that if you wanted a half-an-hour guide to what's involved in drafting privacy notices. Our data sharing code of practice expands on what you need to tell individuals when sharing their data, but as a quick reference guide, you'll at least need to tell them why you're going to share the data and who you're going to share that with. Deciding whether you need to actively communicate information about the sharing to the individual largely depends on how expecting that sharing will be to that individual, the sensitivity of the information, whether it will have a significant effect on the individual, and whether it's likely to be something that they would object to. The general rule in the DPA is that individuals should at least be aware that their personal data about them has been or is going to be shared, even if their consent for that sharing is not needed. However, in certain limited circumstances, the Data Protection Act provides for personal data, including sometimes sensitive data, to be shared without the individual even knowing about it. So an example would be you can share information in limited circumstances without an individual's knowledge in cases where perhaps personal data is being processed for the prevention or detection of crime. But please note, however, that exemptions under the Data Protection Act should definitely not be applied in a blanket manner, and you're only exempt from providing fair processing information if providing that information in itself would prejudice the purposes of that sharing. But I would say that if you're keen to learn more about how the exemptions in the Data Protection Act work, you can find out more information in our guide to DPA on our website. Let's have a little look about security then. So, as many of you may know, one of the principles under the current DPA and under the GDPR is that you must take appropriate security measures to protect the information that your charity holds and that your charity is sharing. Security doesn't just relate to physical measures, but it also extends to technical security measures and organisational security, such as staff being made aware of relevant policies and having had the necessary data protection training. When your charity shares personal data, it's good practice for you to make sure that it will continue to be protected with adequate security by any other organisation that will have access to it. As the organisation disclosing the information, you should ensure that the receiving organisation understands the nature and the sensitivity of the information. It's also good practice to ensure that an agreed set of security standards has been signed up to by all of the organisations involved in a data sharing agreement. However, it's worth noting that the organisation receiving the data will ultimately become responsible for that data as a data controller, including ensuring that it has the necessary security and measures in place. But it's still good practice to make sure that they are taking the relevant and necessary steps to protect that data once you're disclosing it to them. Having effective governance in place where your charity decides to share information is key. Often, the issues that data sharing is intended to address are sensitive, and the decisions that staff members may have to take can require a certain level of experience and sound judgment. It's therefore often good practice for a senior, experienced person within your charity to take overall responsibility for information governance of that sharing. This will help to ensure compliance with the law and to provide advice to staff perhaps faced with making difficult decisions about data sharing. We'll cover what's required by data sharing agreements in a few moments' time, but remember that data sharing agreements in themselves are effective building blocks in terms of having good governance when data sharing. Before entering into any data sharing arrangement, it's good practice to carry out a privacy impact assessment or a data protection impact assessment as they're referred to under the GDPR, so a PIA or a DPIA, but we mean the same thing. The Privacy by Design webinar that we ran in December 2017 explains more about what's required in a PIA and the benefits of carrying one out. So if you haven't seen it, it's certainly worth watching to find a bit more out about your obligations in terms of carrying out PIAs or DPIAs. The standard of the information is also important when you're sharing personal data. So for example, you should take steps to ensure the accuracy of data before sharing it, and make sure that you've got procedures in place for correcting personal data that turns out to be inaccurate, perhaps after you've shared it. The GDPR introduces a right to rectification, which means that if an individual lets you know that data you hold about them is inaccurate, you'll need to take steps to let organisations to whom you've disclosed that data to, you'll have to take steps to make sure that they're aware of these inaccuracies if this is possible. Retention of the information is also linked to the standard of the data. Various organisations sharing data should have an agreement about what should happen to the information once the need to use that personal data has passed. So do you all securely destroy the data or hand it back to the original organisation? But there are issues certainly to consider in terms of retention. Good governance would require your charity to review the data sharing arrangements at relevant periods. Our data sharing code of practice has more information about the types of questions to ask yourself when you're reviewing whether the data sharing is still effective. But an example would be questions such as, is the data still needed? Or is the information still of a good enough quality to share? Under both the current Data Protection Act and under GDPR, it's essential that you consider the rights that we as individuals have in relation to our information. So, to name a few, not an exhaustive list, but these rights include the right to access data held about them, so the right of subject access, the right to know how their data is being used, so the right to be informed, and the right to object to the way that information is perhaps being handled by a charity. Some of the rights under both the DPA and the GDPR will need to be considered on a case-by-case basis, but it's really important for all staff within your charity to know that these rights do exist and to know who to seek advice from within your charity should they need to. Now, I've mentioned already that part of having good governance in place requires you to put in place data sharing arrangements or agreements for routine data sharing that your charity is involved in. The agreement is there to explain why the sharing is necessary, the specific aims you have, and the benefits you hope that sharing will bring to either individuals or to the wider society. So we're not going to go into this slide in detail as it pulls on information we've already covered throughout this webinar, but if you have a couple of moments just to read what's on the screen, you'll find out more about these kind of bullet points on the screen in our data sharing code of practice, but you can see an example of some of the key issues that a data sharing agreement should cover. So an example is, what's our legal basis for sharing? What are the parties that are going to be involved in this sharing initiative? And how are we going to manage as a group of organisations? How are we going to manage individuals' rights? So in terms of the support that's available to you as a charity, I've mentioned this document on the left-hand side so much through this webinar that you're probably sick of hearing me talking about it, but the Data Sharing Code of Practice really is the go-to guidance for any data sharing concerns or queries that you've got. So a lot of the information that's been included in this webinar has been pulled from that data sharing code of practice. We've also got smaller checklists available in English and Welsh on our website that cover on one side kind of a quick overview of the considerations when sharing data routinely, and on the other side what you need to do in the event that you receive a one-off ad hoc request to share personal data. So if you haven't seen those already, you can download them on our website and print them out. Now, we've already taken a poll at the beginning of this webinar to ask how many of you have been in the past refused access to personal data because someone, whether it's within your own organisation or another organisation, has told you that they can't share information because of data protection reasons. So in a way, I kind of wanted to ask the opposite, but I just wanted to have a feel from all of you listening now, having listened to these previous slides, so during this webinar, how many of you feel more confident now, having listened today, that data protection laws aren't necessarily a barrier to sharing information? So again, if you're happy to type in the chat pane as to whether you do feel more confident, whether you feel that actually you're aware that data protection isn't necessarily there to stop sharing data, it'd just be interesting for us to get a feel.
Brilliant. Okay, so this is also an opportunity for you to type in any questions you may have as well.
Indeed.
So going through, excellent. The majority feel more confident or becoming confident. This is good news.
That is, and it's really, it's good news that you do feel more confident because, as we've kind of talked about throughout, neither the DPA or GDPR prevent information sharing, but if you are going to be engaged in any kind of data sharing agreements or initiatives, you now know, or you're now equipped with some of the information in terms of the mechanisms that you need to put in place to make sure that when you do share information, you're sharing in a way that's compliant with data protection laws, whether it's the current Data Protection Act or whether it's the GDPR as of May 25th, so just over 5 months' time. So that's brilliant. If we then go on to any questions, I've got my contact details on this slide if you're not confident asking questions now, or whether some questions come to you later on. But I really hope that this session's been useful, and we will now have a look at what questions are coming our way.
Okay, thanks very much, Bethan. Big thanks, actually, because I know how busy the ICO are at the moment.
Thank
Obviously,
you for
with
having
GDPR
us.
coming in May. So some of the questions then, may we please have access to the slides later on? Absolutely, no problem at all. The code of practice will help us have this conversation with partners who have been less confident about sharing data with us. Excellent. Good that it can work both ways.
Yeah, because if you're constantly being refused information, but you feel that third party should be sharing that, then again, you can refer them to the code, you can refer them to the ICO as well, and we can certainly remind them that, if there's good reason and if the right mechanisms are in place, data can be shared lawfully under data protection laws.
Brilliant. Okay. And more understanding, but I wouldn't share email addresses if asked without that person's agreement.
Okay, that is a fair comment, but what I would say, and it's a theme that's emerged through some of our previous webinars, that one of the myths surrounding the GDPR is that consent is going to be the kind of be-all and end-all for using personal data. If we look back at that example that I gave in terms of that police example, so when we talked about some of the exemptions under the Data Protection Act, an example might be that if a police, someone from the police came and said, I really need X, Y, and Z bit of information, then in some limited circumstances, you can use information and disclose information without telling the individuals, but more often than not, under data protection law, you don't always need the consent of that individual to share personal data, so people's information.
Okay, lovely. So going through, yes, slides and recordings will be available to everybody. This is, as I explained in the beginning, the 9th desktop data session that we've run. There are going to be 12 in total, and all of them are available on WCVA's website. So please feel free to share with your colleagues, because we've actually focused on quite a range of topics, so it should be quite useful to people. So the links on the website, session useful, lovely. Okay, so I can see that 2 people are typing. So let's just wait and see what these questions are at the moment. So Each charity should have a policy on data sharing question. Are there draft ones that we can borrow?
So it might be that there's not one specific policy that's called the data sharing policy, but what we expect in terms of all areas of data protection is that there's enough policies and procedures out there to allow staff to know what their responsibilities are under data protection. So there's kind of two strands to that. There's the policy side. Every charity that's involved in data sharing should have a data sharing agreement with an organisation, because that's the effective kind of governance mechanism to make sure that that sharing is achieving what you've set out to share. But whether you have a separate data sharing policy or whether that's kind of encompassed in a wider data protection policy, that would be up to each individual charity to work out how best to get across that information in a policy.
Okay, thanks, Bethan. So thank you, everyone. We hope that you found the session useful. To help us to improve future webinars, there's a link on the slide there. We'd like you to complete a short survey for us. It will also be circulated to everyone who attended as well today. And our next session is Tuesday the 6th of February at 2 p.m. and it's about CCTV. So if you have CCTV on your premises, would be worth you watching that. And the other dates then are 19th of March and the 24th of April. In the meantime, if there are any topics that you want us to cover, please get in touch. Otherwise, we look forward to you joining us again next month. Many thanks.
Thank
Bye-bye.
you. Bye.